Good afternoon, everyone. Welcome to our webinar, Top 3 Mistakes You Must Avoid in Your H-1B Application. I'm Massey, Badmus, attorney with Coles & Thompson, PC, a Dallas-based law firm, and head of the immigration section of the firm. I have 22 years experience in helping employers and their foreign national employees with work visas and green cards. Today, we want to talk with you about H-1B petitions and how you can be better prepared to apply for the H-1B, and even some things that you need to be aware of after you complete the H-1B application or have been approved for the application. Also with me today is attorney Angela Lopez. Ms. Lopez is also a shareholder with the with Coles & Thompson in the Immigration Practice Group, and she has been working in immigration since 2002 with extensive experience with J-1 two-year foreign residency waiver applications, H-1B, professional worker visas, and various other work visas, as well as green card processes. So today we're going to be talking with you again about H-1B visas. And while we're going through that, I want to let you know that you have the opportunity to ask questions at any time. It's like so using your chat box on the screen, or using your chat box on the screen to type and send your questions. And we'll plan to answer questions during the question and answer session towards the end or at the end of the webinar. Okay, let me just make sure we're technically working here. Yeah, it looks like we kind of bumped out of our screen, so let me get back and make sure you see the screen. Okay, so sorry about that little technical difficulty. So the next, what we will be doing is, all right, let me get to this technical issue again. This is coming out again. Do apologize. We will get back on point here. I hit the wrong button somewhere. Here we go. Okay, I think that'll work at this point. So again, let's move forward with the presentation. Okay, here we go. One last time. I'm hoping again that we are going to, you're seeing it, but yeah, it's going out again. Okay. You should be seeing our screen in a minute. A little bit of delay here. Okay. And it blanks out again. I do apologize, folks. We are going to get this straight somehow. Okay, I think we're here. All right, so again, I'm going to, let's get started now with the presentation. So what I'm going to do, as we mentioned, we have 3 top mistakes that you should avoid in your H-1B petition. So what I'm going to do today is talk to you about mistake number 1, and then Ms. Lopez will talk about mistakes number 2 and 3. So mistake number 1 is failing to properly document and prove your eligibility for the H-1B visa. So we're going to go in quite some detail about that to give you some specifics as to what you need to do to make sure that you have the proper, first of all, to qualify that your position and and the applicant, or if you're the foreign national, that you're qualified for the position offered, and then some of the things that you need to look at as you go through that process. So the first thing we do want to give just a basic background on the H-1B visa. An H-1B visa is what we call a professional visa, a temporary visa, non-immigrant visa that basically allows a U.S. citizen, a non-citizen, excuse me, to be employed in the United States for up to 6 years, generally, in a specialty occupation for a specific employer, which is called the petitioner. Now, what's important to note here is the specialty occupation. It's very important that we show that we're going to prove the specialty occupation itself. So what is a specialty occupation? Well, specialty occupation is an occupation that requires generally highly skilled, specialized knowledge, and in most cases, and a bachelor's degree or higher in the specific specialty, which is a minimum for qualification into that occupation. So it's important to note that you need to show the position itself. Not any position is qualified for an H-1B, or any occupation is qualified for an H-1B visa. And that's where issues come up, where the government is very particular about proof that the position itself is a specialty occupation. So generally, or by law, a specialty occupation is defined as a profession which shall include, but is not limited to, architects, engineers, lawyers, physicians, surgeons, and teachers. So what that means is that the law per se says that those specific occupations listed in the law, architects, engineers, lawyers, physicians, surgeons, and teachers, they are always considered to be professionals. But again, that's not limited to that. So if you are not in one of those professions, then you have to go a little farther or further to explain how your position does qualify as a specialty occupation. So what do you need to do that? How do you need to prove that? Okay, so some of the things that we requests from an employer that hires us, or employer and the foreign national employee that hires us to prepare an H-1B petition, is we always need a detailed job description. The government really wants to understand what the position requires and how that necessarily requires a bachelor's degree to perform that position. So a detailed job description is very important, laying out the daily duties and time spent on those duties, so that the government can see that those are high-level positions. So for example, if a person is a marketing analyst, they will be looking at data, doing things that require them to analyze data, do things that are really considered high-level, not just gathering data and presenting data, but doing things that require specialized knowledge and background and education to be to actually perform those duties. So what the government doesn't like to see is that a position has what they think are more administrative or clerical duties that not necessarily would require a bachelor's degree. So you really need to be clear on your job description and explaining the duties that are involved. Sometimes, in addition, we also think that providing information about similar positions in the industry or in your business is very important or helpful. For example, pulling job notices off of Indeed.com or Monster.com or some other advertisement showing that, you know, all of these similar jobs also seek a bachelor's degree and have very detailed or high-level requirements in their jobs as well. So that's some of the information that you can provide to prove the specialty occupation. There's also other things that the government typically asks for and that we would ask for when we're dealing with positions that aren't per se considered to be specialty occupations by law, by the statute. And that would be things like your organizational chart. So if you do have other positions in the company, providing an organizational chart showing how this H-1B position relates to that, to those other positions, especially if it's supervisory, you want to show that there's supervision supervision requirements, which tend to show that it's a higher level position as well. So you definitely wanted to provide that. If you don't have many other employees, or you don't have any other employees, it doesn't mean that you're not qualified for the H-1B, but we will need to provide more information to kind of show how that position is really necessary, or not necessary, is really a specialty occupation. Some other things you can provide are expert opinions and reports, which are available. Many services are out there that can provide that. If they are able to provide, for example, from a college professor that says typically, this type of position does require a bachelor's degree. It's helpful. It's not conclusive to the government, but it is helpful to provide those things. And then also, if your position or the profession has professional associations, there are many out there, physician organizations. Of course, that's not really necessary for physicians, but computer organizations, all types of organizations out there, marketing organizations. And you can show that typically, with those associations or organizations, they have sometimes descriptions about what they expect their members to have. For example, having a degree in marketing qualifies you for this position, that sort of thing. So those are the different types of information that you can provide to prove that your position is a specialty occupation. One other criteria that we sometimes like to use to bolster the proof is to look at the Department of Labor online wage survey. Now, one of the requirements for a H-1B application is that an employer agrees to pay what we call the prevailing wage for that occupation. And so we normally go to the Department of Labor online wage survey, which has hundreds of occupations. They don't cover all occupations or in terms of all titles of those occupations, but they do provide generally information about specific occupations. So for example, if you see here, we have the online wage survey for the occupation of civil engineer in the Dallas area. So just to be clear, these online wage surveys are related or are determined by the location of work as well as the occupation itself. So here we're looking at, let's say we want to find out what the wage typical or the minimum wages required for an engineer, civil engineer in the Dallas area. So we pulled up this online wage survey and we see that there are 4 levels of wages. Level 1 starting with really entry level, someone just completing their bachelor's degree, and then the other levels are based on higher education or more experience. But if we look at this chart, we will see that the level 1 wage is $62,000, which is helpful, but more helpful to us in terms of the occupation, or showing that's a specialty occupation, is where we see there is a description of what civil engineers do. It's a general description. It certainly isn't necessarily specific to any particular employer, but it shows that what the general requirements are, and it also shows an education and training code, which says that typically this position requires a bachelor's degree. So for similar types of positions, if we pull up this data and we see that the Department of Labor also says that there's typically a bachelor's degree requirement, that is something we also want to point out to the government as as proof that this is a specialty occupation. So now that we've proven or determined that the occupation is a specialty occupation, we also have to show that the employee is qualified for that position. And so qualifications, again, as we mentioned before, a specialty occupation has to require a bachelor's degree as a minimum. And so the employee needs to have that bachelor's degree and the specific degree that matches with that position. So if you're looking at a position, of course, as an engineer, you need to have an engineering degree. If you are a position for marketing analyst or a marketing manager, typically a business or marketing degree would be specific to that occupation. And of course, in the IT industry, certain, for example, software engineer or computer programmer you would be looking for someone, of course, that has that kind of background and degree that would meet that. You also have an option in some cases where if that person does not actually have a full bachelor's degree or the equivalent of a bachelor's degree in the United States, you can sometimes, if they have experience, use experience to equate to a bachelor's degree. So for example, the rule is that for every 3 years of experience is equivalent to 1 year of education. And so if you get a credential evaluator that can look at that experience and say, yes, this person has 3 years of experience or 6 years of experience and an associate's degree or a 2-year degree, that is still equivalent to a U.S. degree. Or if a person has 12 years experience but no degree, that could still be equivalent to a bachelor's U.S. bachelor's degree. So, of course, that would be something that a qualified credential evaluator would have to present in their report to show that the employee does actually meet the requirements. And then the last qualification that you need to look at would be if the position itself does typically or does require licensing by the state in which the position is located. For example, a physician, engineer, accountant, or CPA, architect. If your position actually requires licensure, then that H-1B employee needs to be fully licensed in that state, in the state of employment. So they need to apply and show that they have that license. In some states, they will not issue a license unless the employee has an H-1B visa already. And in that case, they will provide a letter stating that the employee is fully qualified except for not having the H-1B visa. That letter will be sufficient usually to present to the government in your H-1B petition so that that individual can still get the H-1B approval even though they're not yet fully licensed. Some of the other to prove the qualifications of the employee, of course, you always want to present their diplomas and their degrees, whether they're foreign degrees or U.S. degrees. If they are foreign degrees, you want to be sure that you get a credential evaluation from a U.S. Qualified credential evaluation company that can state that the degree is equivalent to a U.S. degree, U.S. bachelor's degree, or the experience and degree are equivalent to that. If you do require experience in your application, then you should probably obtain letters, or the employee should obtain letters showing that they have that specific experience, and of course showing that they have a professional license if that's required for the position. The next area that you need to be sure that you meet, or qualification you need to meet for the H-1B petition, is what the government calls establishing the employer-employee relationship. And that seems kind of simple because, of course, if you're hiring someone, then you would expect the government to consider that you are their employer. However, in some instances, the government questions that relationship, particularly if your employee will work off-site. So, for example, in IT positions, oftentimes our employees are placed at the client site performing work there. For physicians, sometimes they will be placed at hospitals to work at the hospitals, although they're specifically employed by the person applying for the H-1B visa. But the government considers those third-party sites where the employee is not actually working at your site, but working at a customer or client site as a red flag to them that maybe the employee-employee relationship is not there. So in that case, you need to be prepared to have additional evidence with such things as employment contract or offer letter, your employee manual showing that how you control your employee manual, how you provide benefits and have certain rules and requirements for the employee to conform to, showing that you do conduct performance and reviews of your employees regardless of where they're working. That in addition, you may also show that you have contracts with the clients where you will provide the services on site. However, the contracts are very clear that you are the employer, or the petitioner is the employer and not the client. and that you're responsible for pay and any discipline and all kinds of things that are normally associated with the employee-employer relationship. And of course, showing pay records that you are directly the payer of the salary to that employee. Beyond that, sometimes, especially for smaller employers, the government also wants you to prove that there is what they call a valid job offer and position. Now, with the H-1B petition, proving your ability to pay is not supposed to be an issue. So the focus should not be on the government whether or not you have sufficient income or profitability in order to pay the employee or resources to pay the employee. But a lot of the information that they ask for are financial information, what seems to look like that's what they're looking for. But actually what they state they're looking for is to prove that there is a valid job offer and position. And so there's where we do still sometimes need to provide things like your federal tax returns of the employer. If you have if you have current payroll showing that you've paid unemployment tax, have employees that you're paying unemployment tax on. Organizational charts here are helpful in that sense to show the different employees, and then showing your payroll records as well as company history are always helpful as well. So this is just really background, and so that the government feels like you are an actual business that does have or does intend to hire this H-1B employee. One of the other things that they also do as part of the process is a process of reviewing your application and determining whether it's approvable, is they look at a database called the Validation Instrument for Business Enterprises, VIBE program, which is run by Dun & Bradstreet. And so many of you probably are familiar with Dun & Bradstreet, keeping sort of records or sort of a database where people can get information, general information about a company and its viability and sometimes credit rating. So the government looks at VIBE really just to see if it is actually an existing company, although certainly VIBE shouldn't be the last determination of whether a company actually is in existence, because many companies are not on Dun & Bradstreet's system. But that is something that they often look at. So they sometimes will send a request for information saying, well, we see that we're not on VIBE, we can't find your information, so we need to get more information about your company, and that's where they start to ask for a lot more information. So what might be a good idea if you are a company that's not currently enrolled in VIBE is to actually enroll yourself onto that system. And here we have the website where you can go. I believe that is a free service. The government does tell you you don't need to sign up for there is a paid portion of the service. You don't need to sign up for that, but you can sign up for the free service and at least have your information in the database. So if you do that before you apply for the H-1B petition, it could relieve you of providing a lot more information than necessary. The next category, or the next qualification that I want to mention briefly is and it won't necessarily apply to most people probably on this call, but it is important to know in particular if you are applying for a first-time H-1B employee, you will probably be involved in the H-1B cap process, which Ms. Lopez will talk about later. But if you don't want to be competing for these H-1B visas and H-1B cap, you might be qualified for the H-1B cap exemption. Again, it's very few organizations are qualified for that, but I do want to mention it to you and let you know that just basically what the requirements are in case you may qualify. So there are sort of three categories that we're lumping together here as cap exempt categories, where there is not any competition and for the H-1B visas. And in fact, you can apply at any time of the year if you qualify for these cap exemptions. The first one is employers. Certain employers are cap exempt, meaning that their applications for H-1B are not subject to the cap, and they can apply for any time of the year. And that would include universities and colleges that are public, nonprofit universities, so public or private, but definitely nonprofit universities. So those for-profit universities would not be qualified for this, but most universities are if they're nonprofit. And so that's an easy category. If you have proof that you are a nonprofit university, then you will be able to apply for any H-1B employee for cap, and they will not be subject to the cap. There's another category of employers. These are nonprofit organizations that aren't actually teaching institutions, but they have affiliations or associations with these teaching institutions. And so, for example, they may have a training program where students from the universities or colleges come to that nonprofit organization and get training in their specific field. If the organization can establish that they are this type of organization where they have this affiliation, then they can also hire throughout the year without regard for the H-1B cap for qualified positions. There are also government or nonprofit research facilities that are also eligible for cap exemption if they are qualified as such. The other category, that's what we call third-party employment, is for nonprofit. It's for employers who are for-profit. If you're a private employer, and you're certainly not for-profit, not a nonprofit organization, but you will put that H-1B employee at least the majority of the time, which we consider 51% of the time or more, at a university or a nonprofit organization, as like the ones we just described, then you can also qualify for cap exemption, provided that the employee will be providing services that the government or that you prove are related to the educational purpose or other nonprofit purpose of the university or the affiliated nonprofit affiliated associations. And then the last category is very specific to physicians who received a J1 physicians who received a waiver of the 2-year foreign residency requirement through government sponsorship, not hardship or persecution waiver, but through government sponsorship, such as a Conrad 30 program or a federal government program. If you have gone through that process, then you are cap exempt throughout your whole time on H-1B, whether it's with the initial H-1B J1 waiver employment or afterwards, after you've completed the J1 waiver. So just generally to go over cap exemption, because it is an area that has had a lot of issues in the past and still continue to have issues in determining whether or not an employer is cap exempt. As I mentioned before, certain employers are cap exempt, and so you have to prove that. Of course, if you are a higher education organization that's public or nonprofit, it's pretty easy to prove that. You just provide your proof of your status, your nonprofit status, proof of accreditation, and proof of your curriculum that you do provide at least an associate's degree or higher, or 2-year education program or higher. So really where the question comes in most, or the next two categories, or the problems come in most, are the next two categories of nonprofit affiliated with a higher education institution. The government, and the third-party employment. The government has been very, I would say, difficult in terms of, and inconsistent in terms of stating or approving applications by nonprofit organizations that are affiliated with higher education. What they say is that to be a qualifying institution, which means you are qualified as cap exempt, you need to show that you have shared ownership. That has been sort of what they've been saying recently, or in the past 5 years. The criteria is showing that you have some sort of shared ownership with the higher education institution, and that, of course, is a problem because most of these nonprofits that have affiliations through clinical training programs or clinical training agreements, they aren't owned by the university. They're just in cooperation with the universities in order to provide those very important training that these students need. But you also have had times that the government has approved specifically that situation where there is not shared ownership, but there's clinical training agreements involved, and the organization has proven or has been approved for cap exemption on that basis. But just to give you an idea, I've had cases where we, in the past, about 5 years ago, applied for 3 different employees, but with the same position, going to the same employment, nonprofit organization with the same affiliation, and we get 3 different decisions. One approved immediately, one approved after a lot of questions, and one denied, and saying that that organization was not cap exempt. And the reason why we got 3 different decisions is because we had 3 different officers reviewing those applications. So that inconsistency has been a problem for many applicants. And so because of that, the government in 2011 stated that, well, we haven't really been able to get a rule out there that makes it more consistent so our officers really know how to deal with these applications. So instead of coming up with a rule right now, because we'll get around to that later, we're going to just let you know that if you have had previous petitions since June 2006 that have been approved for cap exemption, that we will defer to those. We will honor that determination unless there's been some drastic change in the organization. And so what's important if you are trying to claim cap exemption is to try to obtain previous cap exempt petitions to show and present that with the new petition showing that, yes, we've already been determined as cap exempt. There's nothing that's been changed in our organizational structure. We are a nonprofit or affiliated with a university, or we have, or we are placing a physician or a person at a nonprofit affiliated with a university. And so we should be given deference to that. Sometimes that requires a lot of digging around if you don't consistently work with H-1B cap exemption, or if you're the location where the employee will work doesn't consistently do that. But it's a good thing to try to find that information. It doesn't mean that you can't be approved without it, but it is very, very helpful, and you have a greater chance of being approved for cap exemption if you have that previous petition. So now we'll go on to mistake number 2. Ms. Lopez will talk to us about failing to observe timelines and deadlines.
Good afternoon. Thank you all for being with us this afternoon. On mistake number 2, failing to observe timelines and deadlines. This is, I think, one of the key elements or factors that will determine whether or not you're going to be able to obtain an H-1B visa. When we think about timelines, especially when it's related to an H-1B cap subject application, as Ms. Badmus was explaining to you before, we always advise employers to start working on the applications early in the year so that the application is completed by April 1st. And the reason for this is because am I in the right? Hold on, excuse me. Let me just.
Here we go.
Okay, so the reason for this is that the H-1B visa program has a numerical limitation, and that's why we refer to this as the H-1B cap. Ms. Badmus talked to you about the exempt petitions, so we don't have to worry about those when we're talking about H-1B cap petitions. The cap or the numerical limitation is the Department of Immigration only has 65,000 new H-1B visas per fiscal year. Fiscal year for immigration purposes goes from October 1st to September 30th. These 65,000 visas per fiscal year, this is exempt from Free Trade Act FTA nationals. They also have 20,000 fiscal H-1B visas per fiscal year for persons who hold U.S. master's degrees or higher. And they apply to first-time H-1B or previously cap-exempt H-1B employees. What this all means is that if you are one of those employers that do not qualify as an exempt petitioner, and or the person that you are going to sponsor for the H-1B visa is not exempt, like the J-1 physicians that Ms. Badmus was mentioning before, then you will be subject to filing your H-1B petition under this program. And that means that if you're the person that you have in mind to sponsor for the H-1B doesn't have a master or higher degree, and unfortunately, MDs are not considered to be higher degrees. So if the person doesn't have a master in the United States, then you will be limited to the 65,000 visas. If the person has a higher, the master's degree, then that person or your application will have another chance to qualify, because it will not only be considered for the 65 regular normal or H-1B cap petitions, but also within the 20,000 additional slots for master's degrees. And who is, Ms. Badmus mentioned who was exempt from this cap. So which means that if you are first time, if you are filing the H-1B petition for the first time, then you are subject to this. Or if you were working with an institution or with an employer of your candidate, the person you're going to sponsor was working for an institution or an organization that was exempt, as explained by Ms. Badmus. If they are now going to work with an organization like yours, for example, that you are cap subject, then these petitions will be subject to the cap or numerical limitation. So what is the timeline? We always ask people to keep in mind the following dates, sort of say things. When you filed an H-1B visa, the rule is that you can file the petition 180 days before the employment start date. For H-1B cap subject petitions, because the fiscal year starts on October 1st, then the employment will start on October 1st. It could not start before October 1st, because the visas will be available as of October 1st. Therefore, the Department of Immigration allows based on law that the people that are filing these petitions file them 6 months ahead of time, or 180 days before, which if we go 180 days before October 1st, it will bring us to April 1st. So what you see here in the slide is that we recommend people to start working on the H-1B. The latest is February. In February, meaning start working and preparing the petition, not just working in finding an employer, or the employer trying to find a candidate for the position. Because what you want to do is that you have at least 2 months, which is February and March, to prepare your petition. We strongly advise people to start before February, but certainly not late after February, because time may not be enough to complete the petition and file it by April 1st. April 1st, because the Department of Immigration starts taking those applications on April 1st. And what we have seen year after year is that attorneys like us and employers that understand the cap exempt, not cap exempt program, they do file these petitions by April 1st. Traditionally, the Department of Immigration accepts these petitions the first 3 to 5 days of the year. So they might be accepting petitions from April 1st to April 5th. And all the petitions that get there, they're going to be accepting them. Just to give you an example, last year in 2015, they received over 200,000 petitions for 65,000 or 20,000, and for a total of 85, we're looking at the total numbers. So what they did was, obviously, review petitions in general to see if they met the minimum requirements, which was that they had all the forms and they had all the checks to process the petition. At this stage, they're not looking at whether or not the petition qualifies to be approved. They are looking at minimum filing requirements, which are checks, right place of filing, and also that the forms were all included. If the petition meets that those minimum requirements, then they close they close it, and they do what is called a lottery, and it's really a lottery because they take all the applications that were filed and they first do the lottery for the master's petition. So they do select the 20,000 petitions to be processed under the master program. And anything else that is left, let me just give you an example. If they receive 30,000 petitions for the with master's degrees, they select the 20, then they take those 10 that are left and put it back into the 65,000 pool. So they do the next lottery for the 65,000. And once they select the ones that are going to be processed, if you're selected, it doesn't guarantee approval. It just guarantees you that the petition is going to be reviewed and processed. So they do send rejection notices along with the petition, or they send notices letting people know petition made it and we're going to process it, and here is your case number. One of the things we see and we recommend, if people need to know as soon as possible whether or not their petition was accepted, then they should file the petition via premium process or expedite process. The expedite process, you can request it up front. Some of you might know that guarantees the Department of Immigration will process the petition in 15 days. But that premium processing time will not start running until they have complete the selection of the visas that are going to be processed. Once they know which one are going to be processed, then they will start working on the premium processing visas immediately, because those are the ones that are subject to being completed in 15 days, or at least having some sort of decision, which is in some cases a request for additional information. It doesn't mean they're going to say yes or no, approve or not approve. It's just that they are reviewing it, and within 15 days, you'll get either a decision approved or most frequently just an RFE. And I say frequently is because I have not seen, I mean, I can't remember ever seen a denial without having an opportunity to produce additional documentation. So you either get an RFE or you get an approval. Finally, the decisions, what we experienced last year is that by July, August, we were receiving, again, the request for additional documentations or the decisions. And then so people, the ones that were approved, they were ready to start working on October 1st. The rejection notice may take a little bit longer. At least what we experienced last year is that a few applications that were rejected in our office, the ones that we filed, I received one of those petitions in October. So it took them that long to process the rejections, because their main focus is on the visas that they have to process. So timing when it comes to H-1B cap subject petitions is of the essence, because we want the petitions to be there by April 1st. Yes, if we're not able to file it by April 1st, we don't want it to be too late, because then we may run the risk of not even making it to the petitions that are going to be done within the lottery. So what we usually tell people is you need to prepare. This is January, and if you have not talked to an attorney about your petitions, you need to do that now. You need to start gathering and producing the necessary documentation, as explained by Ms. Badmus, and information so we can prepare the H-1B visa petition. please keep in mind that because it's a petition that is filed with the Department of Immigration, there will necessarily be forms and documents that employers have to sign before we can submit the petition. And there will be preliminary steps that will have to be taken before we can file the petition with the Department of Immigration, such as, for example, filing the LCA or labor condition application, which takes at least 1 week to get certified. So right there, you have a week that you really couldn't do anything in terms of filing a petition. So, and then make sure that you have plenty of time, and we, as the attorneys working on the petition, will have plenty of time to complete the petition and have it reviewed and ready to be filed by April 1st. No later than April 3rd, because you never know when they're going to be, and they usually let people know when they will be closing the program. But we want to get it there as early as possible. So deadlines in terms of preparing for an H-1B cap subject petition, you really need to keep in mind and be proactive in meeting those deadlines so that your petition is filed on time. The gap timelines for F1 students. If you are familiar, if you're not familiar with this, let me just give you a brief information, a brief explanation. F1 students, or students who are here on an F1 visa, at the end of their programs, they receive what is called an OPT, or employment authorization work documentation. So when they work with these EADs, the EADs or OPT cards or employment authorization documents, they have an expiration date. Usually, because these programs end at the end of May or June, the cards usually have an expiration date of May or June, depending as to when the card was issued. So the student is able to work with an employer once they finish the program, and at least through the expiration date on the EAD or OPT card, which more in most cases is June or May of the following year, they end their program. So what happens with these students, and this is what is called the cap gap, when a petitioner files an H-1B visa petition with the Department of Immigration under the CAP program, meaning April 1st, the documentation will show that the person or the employee or the professional that is being sponsored has an employment authorization document that will expire sometime during the summer. So what we want, or what you want to see with this petition, is, first of all, it was filed on time. Second of all, that it was selected for the lottery. And third, you want to get the receipt notice, because with that receipt notice in hand, then the F student will be able to extend his employment authorization document or OPT at least until September 30th. So, for example, if he's applying for an H-1B visa this April 1st, what you will see is that the student will be able to continue to work with that employment authorization document until September 30th, 2016. Some F students or people who submit these petitions for an F student, what we have seen, some cases they might want to premium process the petition, so they get a receipt early enough so that they can go to their international representative at school and complete the paperwork for the EAD to be extended through September 30th. Once the OPT is extended, then the student will be able to continue to work until the H-1B decision is made or October 1st comes along. What will happen is then the Department of Immigration will process the H-1B visa, and once approved, they will, in the notice of approval, they'll show that it's effective October 1st, which means the student will not have H-1B status until October 1st. So his last date of employment with the EAD will be September 30th, and on October 1st, he can continue to work without any interruptions, but in H-1B status. If by any reason the H-1B is denied, then the student has 60-day grace period, which will begin on the day of the denial, to either file another petition that will allow him to stay in the United States or make arrangements to leave the United States. So it's not that if the petition is denied, the student will have to leave the United States the next day. They'll have 60 days where they are still considered to be in F status to make arrangements to either get another visa or leave the United States. If the OPT expired and the H-1B is filed before the expiration of the 60-day grace period, the student can remain in the United States until the H-1B petition. And that goes to being able to extend the the OPT program. I'm sorry, if the OPT expire and then the person might not be able to continue to work, but he will be able to stay in the United States. And then, as I was explaining, if the H-1B is denied, then the student will have to either leave or the 60 days period do something. Okay. Now, H-1B renewal timeline. So we have so far seen the timeline for filing the H-1B petition, CAP subject, filing and making sure that if it is an OPT that has to be extended, getting that receipt notice for the employment authorization document to be extended, so the student can continue to work. And now H-1B renewal timeline. Well, the employer must submit the renewal petition, which is another H-1B petition, follow the same steps that were followed when the petition was submitted for the first time, and Ms. Badmus went through the steps to take to make sure you file a good petition. So you have to submit the renewal petition, and it followed the same steps for the renewal petition. And that has to be filed before the H-1B visa expires. So for example, if the H-1B visa was granted the first time and it expires on July 30th, so then you can start working on the petition early in January, because it's 180, or you can file the petition as early as January, beginning of January, and count in January to count the 180 days. Once the petition is filed, then the H-1B status and work authorization, because that's what the H-1B is a work authorization. So then it exists by law. The employee can continue to work up to 240 days after the H-1B visa expires, as long as the renewal petition was filed timely. And by timely, we mean before the visa expires. So we go back to the example of the petition. The H-1B expired on July 30th. The petition was filed on July 20th. So July 30th comes around, and no problem for the employee to continue to work and continue to have legal status in the United States, because the law extends this status for up to 240 days. Premium processing is available. We know what is premium processing. The Department of Immigration will process the petition in 15 days, so that can also be expedited. We recommend, as always, start working on the petition early enough, 6 months, 180 days before the expiration date. File the petition. Regular time for H-1B processing is about 4 months, 4 to 5 months. So you should have plenty of time to get it approved before the other one expires. However, you might want to consider premium processing anyways, because in many states, what we have seen is that the approval of that issuing of the driver's license or the renewal of the driver's license in some states is attached to having an approval notice for an H-1B, which means the H-1B employee won't be able to renew the driver's license until they have that approval notice in their hand So that might be something to keep in mind when processing these H-1B visa renewal petitions. Also, if the person has travel plans, and you want to make sure the petition is approved, if the travel plans are within the time that the H-1B visa is going to be expired, so that there's not going to be any problems for the petitioner, for the beneficiary, the employee, to go and apply for an H-1B visa stamp to return to the United States. Or other issues that might be a fact in determining how soon you need that H-1B visa petition to be approved. H-1B, oh, I think I went again. Page down. Okay, H-1B amended petitions. When do you need to amend a petition? We always tell employers, once we get an approval of the H-1B visa, to let us know if there are any changes in the employment. And changes include if you are reducing, or the employee wants to reduce the number of hours from full-time to part-time. If the H-1B visa petition was filed for full-time, and by law, the employer defines what is full-time: 32, 34, 36 hours, 40 hours, 36 to 80 to 40 hours is most commonly used for full-time. But if the person is going to start working part-time, 20 hours or so a week, then you will necessarily have to file an amendment petition with the Department of Immigration for them to reduce the number of hours on the records. If the duties change, if the job duties change from one specialty to another, and we're looking at substantial changes. It's not just a couple of things that he's going to be doing in addition to all the other things he's always been doing. It's more a substantial change. So if he is going from being just an employee to a managerial position, definitely you will need to file an H-1B amendment petition. Changes in place of employment, those are kind of tricky. In general, we advise employers to amend the petition to avoid any problems. But if the employment, the place of employment is going to change, for example, you move to a new address, and the new office is 2 floors below the current address, I wouldn't worry about filing a new H-1B amendment petition. If you're moving only a couple blocks from your previous address, as long as you are within the same city, then you should be okay. The Department of Immigration always talk about the metro statistical area. That might be a little bit complicated, although you can and you can get on the website and look for what is the metro statistical area for the job you are located. In general, we always tell employers, please let us know. We'll do and take a look into the changes of employment location to let them know whether a new H-1B is needed. This is very important to do it before moving addresses, because all these amendments, or before starting to the employee working part-time, or before you change the job duties from one specialty to another. So the timeline here is you need to get the H-1B visa amendment petition filed before these changes take place. So you will need to plan ahead. Now, mistake number 3 is failing to prepare for international travel and government audits. These international travel, when an employee who has been a sponsor for an H-1B visa is in the United States, and they either change from, for example, for an F student, they change to H-1B status, or if they already had an H-1B and they are extending the H-1B and the other expired and the new one took effect, so and they want to travel outside the United States, they will be required to go to the U.S. embassy or consulate at the respective country, or the home country. Most frequently is home country, although some people might be able to apply in a different consular or embassy from their home country. But for the purposes of this presentation, let's talk about home country, okay? So when a person has to file for an H-1B visa stamp to be able to return to the United States, what we want them to keep in mind is, first of all, to check and file and try to obtain an interview for obtaining the visa before they leave the United States. Because usually when you file outside, when you travel outside the United States, you only do it for a couple of weeks. So they can make arrangements before they leave to know when the visa interview is going to take place, so they can stay within the time they're planning to be outside the United States. However, there are a couple of things that need to be taken into consideration, because that might affect the return to the United States within the time they had planned. So when they go for this visas interview, and there's specific requirements and specific documentation that they need to take for their interview and to get the visa stamp, couple of things might happen. One, they go to the interview, the consular processes, the consular officers will review the documentation, and in most cases, if everything is good, they'll approve the visa, and within a couple of days or maybe within a week, they receive the passports with the visa stamp so they can return to the United States. In some cases, the Department of State, which is the one that runs the embassies and consulates around the world, they do what is called an additional administrative review, and that's what we go by mention here when we say administrative processing delays. So the additional administrative review, in most cases, is, yes, we review you had your interview. Yes, we review your paperwork. However, we are going to do a more in-depth review of your application. In most cases, these reviews are done randomly. Most cases are not selected for additional administrative processing reviews, but when they are selected, then people have to make arrangements to stay outside the United States as long as the Department of State takes in reviewing the petition and issuing the H-1B visa. This is a kind of a difficult topic, because in some cases, some of these reviews take weeks and months. And so employees will have to remain outside the United States. Then and that implies employers have to make arrangements to be able to continue to function without this employee and until they return to the United States. Now, the Department of State may also return the petitions to the United States. Why would they return a petition? Well, sometimes if during the reviewing of the petition they find out that there are some problems with the petition, that at the time of the interview the petition is no longer approvable, or they have questions about the approval of the petition, they may return the petition to the Department of Immigration here in the United States, and they would have to provide a memorandum explaining the reasons why they are returning the petition that the Department of Immigration previously approved. And when they return the petition, usually they also deny the visa, the H-1B visa. If they deny the H-1B visa, they do give a letter to the person applying for the visa explaining the reasons for the denial. The Department of Immigration receives the visas here, the return applications, and they may do one of the things. One, just make sure and decide that there's nothing to be revoked, that the petition should not have been returned, and return the petition back to the Department of State or the consular or embassy for them to issue the visa. Two, they may just revoke the visa, or they may revoke the H-1B visa, and therefore the person won't be able to obtain an H-1B visa through that petition. Or finally, they may just send a letter to the petitioner asking for additional documentation or information with an intent to revoke, so they will give them an opportunity to do something before they revoke the visa. If the visa is revoked, well, then the person won't be able to come to the United States. If if it is not, then they can complete the process. So these are a couple of things. The administrative delays, the additional administrative reviews happen more frequently than the visas returned. They are not in the business of returning visas, although it happens, it doesn't happen very frequently. Okay, now USCIS audits. This is another area where time is of the essence. There are time lines, and we need people to kind of be aware of this and make sure they do things within the required time. The audits that are done by the Department of Immigration they're done randomly, and what is happening is that since 2009, the Department of Immigration created a fraud detection and national security department, and this is the department that is conducting the audits. They What they do is when you have an H-1B visa approved or a petition, they might select petitions randomly, as I mentioned. However, there are instances, and we have seen, or some of the statistics show that many of the audits happen in companies that have less than 15 employees, that have less than 10 millions in sales, or that have file H-1B visas for specific jobs like accounting, business analyst, marketing, advertising positions, which are not the traditional positions that most people say they are professionals. So, but in general, are randomly. What if the site, if they decide to do an audit, they might do it in a couple of ways. One, they may just send a letter to the employer requesting specific information, documentation about the H-1B employee and employment. They may also send an email requesting this, or they may do an unannounced employer site visit. The unannounced employment site visits or all the other requests, what they are looking for is information about the employee. If they go to the site visit, and we have had cases where our employers are visited by the Department of Immigration unannounced. So they want to see the employee. They want to know where is the employee, what is he doing, who pay what for who pay for the visa process, how much is he making, whether the salary is what the H-1B visa petition states he will make. Usually when these unannounced or even announced visas, letters or requests for documentation or the audits happen, employers can um, ask the Department of Immigration to give them at least 3 days to complete the request. It's not something that, and we advise people, if you get one of these unannounced visits or a request for documentation based on an audit, don't immediately jump and give all the information that they might want and then some. But take a look at it, and even if you have the documentation ready or everything ready, just request for the 3 days and just make sure to review the information to provide to the Department of Immigration. So what happens after an audit? Well, the couple of things can happen. The Department of Immigration might find that they need to do further review, and therefore they will transfer the case to ICE or the Department of Labor, and then they will make a decision. And the decision might be that the pending H-1B visa is denied, or they may issue, if the H-1B visa was already approved, they may issue a notice with intent to revoke the previously approved petition, or and they may even file criminal charges, civil fines, penalties, depending as to what they found. And when we're looking at this, we see that there are technical errors or things that were not done correctly. So that may be a fine, that may be a sanction for something, but if there is fraud, then is where we're going to be seeing criminal penalties. We understand in certain industries there might be more issues in terms of the audits than in others, but what they're looking for is that the information given on the H-1B visa is accurate, and then the employers are complying with the terms of the H-1B visa, and the employees are doing what the H-1B visa application specifies. So what do we always suggest people when we say preparing for an USCIS site visit? Okay, the first step is one, review the H-1B petition. Ms. Badmus explained to you about the requirements for the H-1B visa, the salary, the LCA, the postings. When we file H-1B visas, employers should create a couple of files. One of them is the LCA compliance file, the other is public inspection file, the other is audit file. And we usually give people information as to how to complete these files and have them ready in case of an audit. So review the H-1B visa petition, make sure the employee is where he's supposed to be, doing what he's supposed to do, making the money or earning the salary he's supposed to be earning, and that you are also keeping all those files and the H-1B files accurately and in a place that are easily accessible in case of an audit. 2, prepare the compliance evidence files for inspection, and those are the LCA file or the public inspection file that they should be prepared before the H-1B visa is filed. So by the time the H-1B is filed or approved, those files, the compliance evidence files, should already be in place in case of an audit. Third, identify the company representative who will meet with auditors. I always tell my clients, designate a person that if you have one of the government representatives coming to your office or to your company, that this person is the contact and the person these officers are going to speak with. So the receptionist, the person that answers the phones, or whoever is the first contact in your office knows that if it is a government representative, they're going to direct him to that designated person. Not to provide any additional information, but only tell them you will be talking, or this is Mrs. So-and-so or Mr. So-and-so will be meeting, talking to you, and make sure you notify that person so that they can speak to these representatives. And then, and 4, finally, establish site visit procedures for reception, clients, and H-1B employees. Again, you want people in the office or in your organization, if you have multiple locations, to know if in case of an audit, if someone comes and visit us from one of the government agencies, this is how we're going to proceed regardless of the office they visit. For example, if your home office is in a specific city and you have offices in other places, then you will need to make sure that those offices have a procedure for if someone comes and want to see our records or get more information about the H-1B employee. Those are basic recommendations we always ask people to please keep in mind, because having an H-1B employee and having an H-1B visa is a liability, and you want to make sure everything is in place before a surprise visit by the Department of Immigration or missing any of the deadlines.
Okay, thank you, Angela. So that concludes this portion of the webinar. Those are the top three mistakes, excuse me, that you should avoid in your H-1B application and even after the application as well. We also want to remind you that the information we provided here is really very general. Your specific situation may be different, so it's always important to consult with an experienced immigration attorney to address a specific situation before you take action. But we will open now for questions. I did see one question. Again, I want to remind you that there should be a chat feature on your webinar page. So if you go to that feature, you should be able to put in a question. If you aren't seeing that, apologize for that technical difficulty. Please do feel free to email your question to us at the email address that you see now in the in your pane. So let me go to the first, or the right now I only see one question at this point for the webinar, and the question was related to CAP exemption. There was a question that asks, so just to clarify, if you are a nonprofit organization but you're not affiliated with a university or research organization, then you are not CAP exempt, and that is correct. You are not CAP exempt in the sense that you would be considered yourself a qualifying as CAP exemption. However, as I mentioned before, there is what's called a third-party exemption, which basically means that if you are an organization, whether you're a profit or nonprofit, and you put your H-1B employee at a facility that would be considered or organization that would be considered a CAP exempt facility because it is either a university or it is a nonprofit that does have an affiliation with a university, then your petition might still be CAP exempt. But if that's not the situation and you're solely a nonprofit trying to apply for an H-1B employee, but you do not have any affiliation with a university or research organization, then no, you would not be considered CAP exempt. I don't see any further questions at this time. So at this time, I'd like to thank you for attending the webinar. You will be getting a replay, so you can go back and check or hear anything that you might have further questions on. You will also have an email that will give you links to the actual PowerPoint presentations. And then, of course, as always, we do invite you to contact us if you have any questions with your specific situation or need more information as well. So thank you again.